this video, we will be taking a look at the patent filing process in India. Every patent begins as an idea. It is only human to think that the idea you've just had is one of its kind, something that no one had thought of so far. Because if they did, you probably would not be having this idea. Fair enough, but this is where most patent applicants seem to go wrong. Patent filings are expensive and no joke. Each step of the patent process must be thought of carefully and in advance. Once you have an idea, the wisest thing to do is to conduct a prior art search. A prior art basically refers to anything and everything that is known prior to or before the filing of your patent application. Once you have conducted a prior art search, you will have enough information to decide on whether it is worth filing a patent application. Once your idea has crossed this basic hurdle, you can file a patent application with the Indian Patent Office. The IPO has its offices located in 4 cities in India: Delhi, Mumbai, Kolkata, and Chennai. A patent applicant can file the application before any one of these offices, depending on where he or she resides. A patent application may be of two types. The first is referred to as a provisional application, and the other is called a complete or non-provisional application. A provisional application is more like a draft document that, say, you've written in a pencil. It is filed with the IPO to secure a priority date. And when your idea is not yet perfect, or you need some more time to refine the idea. A complete application, on the other hand, is like a document, let's say that you've written in pen. It clearly defines the invention and specifies the claims. A provisional application must be converted to a complete application within 12 months and then filed before the patent office. Once a complete application has been filed, the IPO publishes the patent application in its official journal within 18 months. A patent applicant then needs to file a request with the Indian Patent Office to examine his or her application. If a request for examination is not filed within 48 months, the application is deemed to be withdrawn. Once the applicant files a request for examination, the Patent Office takes up the case and conducts a prior art search of its own. It then issues an examination report called the First Examination Report, or FER, which contains objections from the Patent Office with respect to the substantive and formal aspects of the invention and the application itself. The patent applicant is given an opportunity to respond to the first examination report within 6 months from the date of issuance, which may be extended for an additional 3 months. Once the reply to the FER is filed with the Patent Office, the IPO checks if all the objections listed in the FER have been complied with. If all the objections are addressed, the Patent Office goes ahead and grants a patent. In case there are objections which have not been complied with, or the Patent Office is not convinced with the response, the IPO can issue a subsequent examination report, or, as is most often the case, schedule a hearing between the Patent Office and the applicant. In case of a hearing, applicants have the opportunity of choosing if they want to attend the hearing physically or through a video conference. Once the hearing is completed, the applicant needs to submit a response based on the discussions held during the hearing. If the Patent Office is convinced with the response, it will proceed to grant the application. If it remains unconvinced, it will refuse the application. Normally, it takes anywhere between 4 to 7 years to get a patent grant in India, but by following certain strategies and using some of the provisions extended by the Patent Office, this time can be reduced to 1 to 2 years, and in some cases, even less than 1 year. Thank you.